Recently, the Supreme Court passed a landmark judgment in the case of Hyatt International Southwest Asia, a UAE-based company that provides hotel advisory and consultancy services to hotels in India. It is said to have broad implications on how multinational companies or MNCs are taxed in India. Countries enter into double taxation avoidance agreements or DTAA with other countries to establish which country can tax the income of a company that is earning income in other countries also. This saves the company from the burden of paying tax twice on the same income, once in the country where the income is generated and the second in the country where it operates. As per Article 5 of the UAE India DTAA, the country where a permanent establishment of the company is established is able to tax its income. A permanent establishment is a fixed place of business through which business of an enterprise is wholly or partially carried out. In Hyatt's case, the company contended that it did not have a permanent establishment in India and hence was not liable to pay any tax in India. The Supreme Court observed that, firstly, even though the company did not have an office in India, its employees had physical access and use of the hotel premises that they worked with on site, and hence exclusive occupation and leasing of an office was not necessary to have a permanent establishment in India. Secondly, even though none of its employees stayed in the country for over 182 days due to regular rotation, there existed a continuous and coordinated business presence supported by a 20-year service agreement that allowed continuity. And lastly, strategic HR, financial, and procurement decisions were made by Hyatt International, meaning that it exercised substantial control over operations in India. After taking into account all of these points, the Supreme Court established that Hyatt International Southwest Asia did in fact have a permanent establishment in India and hence was liable to pay tax in India.